Heather is also responsible for keeping maintenance records. Again, it's just part of the physical security of our offices, to the extent that doors have been replaced, windows, anything like that. Not a lot of windows, I guess, but to the extent that one of them is replaced or anything like that, to sort of show that we're keeping up with access to the facility. All right, some sort of common sense rules about the use of workstations. And again, I recognize you don't have unauthorized people in the office very often. But to the extent that someone might be walking around the office, these are just things to try and make sure you don't accidentally have a HIPAA breach because you left your computer screen facing out and someone walked by and saw, oh, I didn't know they had a baby, something like that. It wasn't really their business to learn from us. So try and turn your computer screens facing away from office doors or public areas. If you can't do that, you can just use one of those screen covers, what I'm talking about, where you have to be looking straight on to use it. Highly recommend those. It makes it simple. You don't have to think about which direction your computer's facing. I'm not telling you how to live your life, I'm just saying. Obviously, if you have someone, a visitor, who is not authorized to see PHI, that person should not be left alone in a room with a workstation where that workstation's logged in, especially, but really just don't leave them alone with a workstation at all. If you're up from your desk and you're going to be away from your desk for a while, please make sure you lock your computer before you do that. And if you're going to be up for more than 30 minutes, shut your door, preferably. The door's locked?
Mine does.
Okay, so Sarah, lock your door. All right, and I know that we don't have a whole lot of PHI on CDs or thumb drives or anything like that. To the extent that that you do, if you're done using a CD and that CD has protected health information on it, give it to Heather, who will have the pleasure of breaking it, or sending it to ICS to have it erased and confirm that it's erased. But those things are so cheap these days that just break it. Thumb drive, same thing. If you're using PHI on a thumb drive and you're done with it, we can't be sure just because you hit delete that doesn't actually get rid of the PHI for good. Heather will look, she's putting in a lot of work. She gets to take a hammer and smash it. It's fun. That's the one fringe benefit Heather has for being the security officer. I have smashed a thumb drive with a hammer before. It is super fun. The other types of hard copy or hardware PHI we might be dealing with, paper, obviously we're going to shred that. And that's why we have a business associate agreement with our shredding company. And if you're using a laptop computer, even if it's your own personal one that has been accessing PHI, if you're going to get rid of it, sell it or whatever, don't do that until you bring it to Heather and have Heather send it off to ICS to be wiped, right? Because we need a professional, we need our IT professionals to confirm for us that the hard drive really is wiped and not just, oh, I think I deleted everything. Right? Just because when you think you've deleted things off of a computer's hard drive, most of the time you really haven't deleted it permanently. It can still be retrieved by someone who knows what they're doing. And again, same thing is true with the mobile phones. If you get a new phone, but you've been using DocBook or texting any PHI, anything like that with your phone, if there's even a slight possibility that your phone has been using PHI or has access to PHI or anything like that, a photo of a file, anything like that, bring it to Heather before you get rid of your old phone. Let her send it to ICS to be wiped, and then she'll get it back to you, do whatever you want with it. Okay? Again, we're not going to reuse media unless Heather can confirm with ICS that it's been completely wiped. This is, as I kind of just said, this is sort of a redundant regulation because I think we're just going to destroy any kind of media that has it on there because a CD is about 20 cents. And Heather's also going to need to have a log of all devices being used that might access ePHI. So all the physician and NP mobile phones, all of the workstations in the office, and if there are any personal laptops or personal desktops, anything like that, tablets that people are using. I don't think there are right now, but if there's anyone is able to take work home or something like that, and then Heather needs to have a log of that, and ICS needs to have access to those computers to make sure. I mean, I know that none of you can log on to the Newborn Associates server from home, right?
Well, I mean, some of the billing people can.
Some people who can, all right.
But
But you have to
nobody-
use your same password and username and everything, right. So if you're using that computer for that, Heather needs to have a list. And of course, as I said before, just a reminder, if you're doing billing and you're going home and you're working from home because you're logged in on the VPN, do not save anything to your hard drive at all. If the VPN is down, then you can't work from home, right? Okay, great. Again, this is an ICS issue. I'm just letting everyone know how your computer system works. If there's a server that's being moved, ICS is going to oversee the process of making absolutely sure that, you know, it's backed up and everything is secure before that happens, because who knows what can happen. You move a big server, you know, it loses everything. That's the physical safeguards. Technical Technical safeguards. We've already been over this. The username and password are part of that process that keeps the PHI secure. You should be automatically logged off of your computer after 15 minutes if it's idle. And that's just a regular Windows setting. I'm almost sure that that's already set on your computers, but if it's not, call ICS. It's not. Okay, call ICS and have them do that. Because that's another just security feature that can be annoying, and I apologize. You got to type in your password again when you get back to your computer after 15 minutes, but that's just a basic best practice security feature. And then NextGen also logs off after 15 minutes automatically as well. Again, we have reference to our encrypted connections for communications. I also should let you know that the reason that I brought up not storing anything on your hard drive, it's not just because a hard drive is easier to access in general, it's also because your server is a very secure server. It's hidden behind a firewall, which is an encryption device, and you can't get to it without some serious hacking skills, or more conventionally, your username or password, right? And so anything stored on that server is stored behind that firewall. If you pull it off the server and store it in some other place, your home desktop computer, your home laptop, your phone, anything like that, then suddenly that information is no longer protected by the firewall. And so that's why we've got to keep everything on the server. Okay. ICS is going to audit our computer system every so often and let Heather know if there's any unauthorized activity. There's also a sonic wall on our computer system, which I will not pretend to fully understand. Okay, I'm not going to do that because I don't fully understand it. But one thing I do understand, because I made the ICS guy describe it to me for like 45 minutes. And then he finally agreed that this sentence was an accurate portrayal of what it does. So we're going to stick with that. I'm not going to try and get beyond that. But what it does is constantly keep up with everything that's happening on the system. So for the past 30, so the revolving log means that after 30 days, the first day is replaced by the most recent day, but there's a 30-day log of all activity on the computer system that's constantly kept by ICS. So if there's any unauthorized activity, ICS basically has 30 days to catch it, which they will because they're checking the log at all times. So 30 days is more than they would even need for it, obviously, but this way it's sort of fully secure. There's no way some hacker could use one of your usernames and get in and mess with our system without ICS knowing about it pretty quickly. And even if they miss it for a week, they'll see it because it's a 30-day log, right? And it's also engaged in intrusion prevention at all times, which means not only is it logging what's happening, but it's also trying to stop any hackers or any other type of intrusion on the system while it's monitoring the system. Okay, we went over the basics of the breach notification policies and procedures. And I gave you a basic rundown of this, but here's the official explanation from the regs. The acquisition, access, use, or disclosure of PHI in a manner not permitted under HIPAA, which compromises the security or privacy of protected health information. So that's why, For example, if someone in this room, or not in this room watching this video later, accesses PHI that they're not supposed to access, but doesn't do anything with it, just says, oh, I wasn't supposed to see that, closes it, whatever, that's not a breach, because it doesn't it doesn't compromise the security or privacy of that information. Does that make sense? Okay, and then again, I told you that there are specific content requirements for any notification, for breach notification for the individuals affected. These are those content requirements. We have to send it by mail, and it has to describe the events encompassing the breach. I do find it odd, by the way, that in a set of regulations dealing exclusively, or not exclusively, but largely with electronic information, recently updated to reflect the fact that we all use computers, they specify that you have to use U.S. mail to provide that that notice. But I'm not writing the regs. I would think email would be okay.
Well, if they hacked, then it would go to that person instead of you.
That would be a very specific type of hacking, but I suppose that's true. Yeah, if you send the mail, then it's definitely going to their address. Maybe, okay, that's a good idea. You're giving them some credit. I'll take that. From now on, I'm going to assume they actually thought that through. Okay, so you have to do a brief description of the event, just explain the storyline of exactly how the breach took place. A description of what exactly was breached, what information they actually had access to, anything that the affected individual should do to protect themselves, and what we've done to investigate and mitigate, or what we plan to do to investigate and mitigate, and then contact information for with additional questions. And that includes, so the next to last one there includes, we're going to offer you a year of credit monitoring. If you want to take it, call us, that kind of thing. And again, 500 or more individuals, we need to contact the local media and let them know that it's happened. And then within 60 days, do the HHS online form. Okay, and that's the end of the security standards. Anybody need to stretch? Okay. That is the longer part, the security standards. That makes you feel any better. So moving on to the privacy standard. I told you there's two kind of big buckets for HIPAA. There's the security rule and the privacy rule. So now we're into the privacy rule. The privacy officer is the practice manager. So now we're going to switch over from telling you all the things that Heather has to do to telling you all the things that Sarah has to do. Okay. So personal representatives is a really important concept for your practice, because your patients are never the people you're actually communicating with, right? I mean, is that fair, at least with respect to information? I'm sure that you've all developed ways to communicate with newborns, but you're not telling them about billing, and you're not telling them about their health care, what they need to do to take care of themselves, and that sort of thing, right? So the people you're going to be communicating with are exclusively going to be personal representatives. Okay. Now, under the HIPAA regulations, we are required, not only allowed but required, to provide information to personal representatives as defined by the regulations, the same way we would to the individual himself or herself, right? For our purposes, the only definition, and there are several definitions of personal representative, but for our purposes, really, because all of our patients are newborns, the only definition that matters is a parent, guardian, or other person acting in loco parentis who has legal authority to act on behalf of the child in making decisions related to health care. I'm sure in a very huge percentage of our situations it's going to be the parents, right? But anybody who has legal authority to make healthcare decisions for the child, that's the child's personal representative, and should be treated exactly like they were the patient with respect to disclosing PHI to that person, right? So there is absolutely no issue with providing PHI to a parent or something like that. I mean, and you're lucky, by the way, that that's the case, because in a lot of cases it can be very fraught, right? If a person's spouse wants health information, well, the spouse is not their personal representative unless there's some power of attorney or other document specifying that the spouse has personal representative powers. If not, I mean, you can't, I'm sure, as you're aware, many medical practices find themselves in the middle of family disputes all the time, right? Shouldn't be the case with respect to getting PHI in our situation because, again, our actual patients don't know words. So, move on. Oh, here we go. All right. The exceptions to that rule, of course, and this is another just common sense thing that's codified in the regulation, but we don't treat a person who would otherwise be considered a personal representative as such if you, in your best judgment, reasonably believe that person that has subjected the patient to abuse. My understanding of your practice is that you probably have spent more time with the patients than their parents have at that point in their life, so that's not likely to be something you can tell, but it's possible. If you believe that treating a person as an individual's personal representative would endanger that individual, if you don't think it's safe to share information with that person, or if you just in general believe it is not in the individual's best interest to treat their parent or whoever it is that would be a personal representative as such, you shouldn't do that. You should tell Sarah you've made that choice, okay? For billing purposes, treatment purposes, whatever it is you're doing, if you're saying, look, I got a bad feeling about this, I don't think it's in the patient's best interest to tell grandma, what's going on, or tell whoever, tell Sarah, all right, for this patient, I made this choice and here's why, and Sarah needs to be able to keep a log of that to explain it, okay? I'm sure that will not come up very often.
How deeply are we expected to dig if, say, a man with a different last name tells us he is the father?
Oh, you got to confirm that.
Okay, by the baby's birth date, or?
Well, I mean, yeah, baby's birth. If you can ask what the baby's birthday is, ask what his birthday is. I mean, I can't say for sure, but I mean, do you have records that say the parent's information on it too, or do you just have the baby's information?
We get mothers.
You get just mothers.
Fathers aren't involved.
I see.
But, then maybe, and they have a different last name. The baby may have the last name of the
Right.
father, but.
If you have a reasonable suspicion that the father is not acting in loco parentis, or I mean that's not the right term because he's an actual parent, but if you believe that the father doesn't necessarily have legal authority to act for the child, let's say parents are not married and there's no custody arrangement and it's not clear, what the custody arrangement's going to be, ask the mother if that person is authorized, and because the mother is. Sorry?
Is this person authorized to pay this bill?
Well, to pay the bill, that's a little different. Because if they're calling and saying, I know we owe $200, here's $200, that's not really, okay, great, take it. Because they didn't ask for information. If they're calling and saying, I want to know exactly what treatment this child got, that's where you got to start asking if they're a personal representative, right? And if you're not sure, absolutely don't disclose that to the person unless you can be sure. And if you are struggling and you're not sure and you don't really feel comfortable asking the mother or whatever it is, take the entire situation to Sarah, tell Sarah what the situation is, and she may well call me or Joyce, and say, what do we do here? And we can help you through it, because that's a very case-by-case question. I'm sorry that I'm not.
Baby's date of birth, then.
If you say, you can confirm who they are if you say baby's date of birth and maybe what hospital born at or something like that. Something to make you comfortable that they're the right person.
Okay.
So there's two different sort of questions here. There's the question of, is it the father, which you can probably learn by asking baby's date of birth and hospital and mother's name, maybe, but then is the father authorized, right?
Right.
And that's a little different. But once you've established that the person is the father, you may still need to ask the mother, am I allowed to share this information with the father? Unless, there's a presumption, right, that in Mississippi family law that both parents have the right to make parental decisions, but if the parents are not together, not on speaking terms, something like, there may be a pre-existing arrangement where the father's already agreed, not to have custody or not to have authority. So, it is a judgment call. For this particular purpose, if you don't think it would endanger the child, if you don't think that it's not in the child's best interest, and they know the baby's birthday and the mother's name and everything, and they sound credible, you can use your judgment. But if you that's part of why you're hired is for your judgment, right? I mean, part of why any entity like Newborn or a law firm like ours or anybody hires anyone is because you have to trust folks to make decisions. And so if you don't feel right about it, I would definitely say, or even if you do and you want to just run it by Sarah and make sure that she agrees, I would definitely, you can always say to a person, let me check on this and call you back. Call them back in 2 minutes, it's not going to hurt anything, right?
No, but that's okay. With somebody like that, there's an issue. I mean, but we don't give out any other personal information when we're getting their credit cards.
Sure,
or
well, that's
their
fine.
information.
That's different. If the
Not-
information flow is towards
Yes,
you,
yes.
great.
Right,
But if
we
they're
don't-
calling and saying, I want to know, what you guys did to my kid, what treatment did you provide? That's PHI. That's protected health information. And they may call the hospital anyway. It sounds like, it may not be something they call you all for very often anyway. And if that's the case, then I hate to say it's not your problem, but it's not your problem. But that's a good question. Okay. Yeah, what's happening here? Well, okay, here we go. Did I skip 2 or? It's not great. Oh, all right. Okay. Sorry, guys. The irony of a technological issue during this.
That's where we were.
Yeah, well, but it won't let me, will you turn it into a slideshow?
Well, they've got it in front of them, so if
Well, that's true,
you
if I
can
need
see
it.
it, yes.
Here we go, all right. Okay, so what is authorized disclosures are when you disclose PHI and you know for sure that you're allowed to do so, right? You can always disclose PHI to the individual who's the subject of that PHI, or as we discussed, in our case, that's always going to be the personal representative. You can always do that. You can always disclose it to an insurer or a collections agency or anybody required for our own payment and our own healthcare operations. You can disclose, to other hospitals if you need help and things like that. You can, if another healthcare provider is going to take over the care of a patient or help with the care of a patient, you can always disclose PHI for that purpose. If there's another covered entity that's trying, you guys know what I mean when I say covered entity, by the way? I mean a practice like you guys or an insurer, anybody that's subject to the HIPAA regulations. That's what a covered entity is. For the payment activities of someone else, if another covered entity needs the information from you in order to get paid, or if it's incident to another permitted use or disclosure, meaning sort of you're disclosing a part of PHI and another page or another few pages comes along with it. And then finally, where it's been de-identified, and there's a specific regulation cited here, 45, section 164.514B, that says all the things that has to happen to a set of PHI before it's considered de-identified. Probably not something you guys will ever want to deal with, but if some study, someone wanted to do some sort of study and asked you for information about your patients, to share that you would need to de-identify, or they would need to de-identify the information. Probably you could just say no. You could also call us, and we can help you do that. All right, when is it required? So those are authorized disclosures. You can do anything on the last slide. You are required to disclose PHI and EPHI when an individual or an individual's personal representative, so a parent calls and or writes and is seeking privacy protection for that PHI. So in other words, they call and say, I want to see what it says, and you know, for the purposes of keeping it for myself. If they want to know, if someone calls and says, I want to know whom you have disclosed our PHI to, that you have to let them know that, and that's something that Sarah will keep a log, and it's in the policies that Sarah keeps a log anytime a person's PHI is disclosed to an entity outside of Newborn Associates. Not counting like if you send a bill out, you don't have to record that every time. But, or if the HHS secretary is auditing us or investigating us, obviously you can disclose information to HHS directly. If you as a practice want to or need to use any individual's information for marketing purposes, aside from face-to-face communications, like, you know, you run into someone whose friends have used the practice for their child or something like that, and you talk about that as a word-of-mouth kind of marketing deal, that's fine. But if it's a different kind of communication, you need written authorization from someone before you can use their information for marketing purposes. And of course, should go without saying, does go without saying, but I'm saying it anyway, the practice will never condition the provision of treatment or any other services on whether a person approves or authorizes use of the information for marketing. Okay, this is in bold, so you know it's important. Under no circumstances shall Newborn Associates or any member of its workforce sell any individual's PHI or EPHI, right? I mean, if you think about it, you know, every vendor from whom you've ever bought anything online is selling your information all the time, right? That's what they do. They aggregate your information, what you bought, all that stuff, your marketing data, and they sell it to marketers. We are not going to do that. We are not allowed to do that. Not that we would, not that we are in that business, but that's what it means when I say sell information, right? It's defined in the regulation as a disclosure whereby the person doing the disclosing gets money for it, right? I mean, it's pretty straightforward. It's not a sale, so all of these little non-capitalized for some reason bullet points are exceptions to that rule. So if there's a public health study going on, let's say, and we provide information to, let's say, a university or some entity like that that's doing a study, they're also a covered entity. We get a business associate agreement with them, so we don't have to de-identify like we just talked about, and we're going to provide the PHI to that university, right? We can do that, and we can accept a little bit of money for the cost of producing the PHI, and that's not a sale, right? Does that make sense? Because it's for public health purposes. Same type of deal for research purposes. I guess actually that example is more research purposes. Treatment and payment purposes. If Newborn Associates is merging with some other practice and you share with that practice, that's not a sale. If it's provided to a business associate and it's for the purpose that the business associate is affiliated with us. So, for example, you know, providing paper documents to the shredding company to be shredded, that's not a sale. That's not problematic. And anything that's required by law certainly is not an illegal sale. Okay, we addressed this briefly earlier, but this is sort of a longer explanation. But the minimum necessary policy that I addressed before, it basically says you can use only the exact amount of PHI, the exact PHI that you need to perform the function that you are performing, right? And that's the simplest way to think of that. And if we receive a request to disclose PHI or EPHI outside of the office, that's another area in which we will say, as a matter of policy, that we're going to provide only the minimum necessary for the purpose that it's being requested for. Here's just a list of, obvious specific things that you can disclose if you're making a claim to a health plan. I think you all know this anyway, or those of you that need to know it, but this is just for peace of mind within the policies. There's nothing wrong with disclosing this information. Okay, when does the minimum necessary policy not apply? It's when, again, if a person is trying to get their own information or their own baby's information, you don't have to worry about minimum necessary. You just give them all the information they want and maybe just all the information you have. If you're providing information to another healthcare provider for treatment, you don't have to sit there and think, okay, what is the absolute, what do they absolutely need to provide care to this patient, and worry yourself with providing too much information to another healthcare professional who's going to be treating the patient. I mean, in that case, I think we'd all agree the more information, the better. So certainly no minimum necessary requirement there. Don't stress yourself over that. And then, within the practice, if one nurse practitioner or physician is asking another nurse practitioner or physician for information to help treat a patient, or if one billing person is asking another billing person for information to perform that function, anything like that, within the practice, there's no minimum necessary requirement. And certainly, again, consult with Sarah if you're not sure what the minimum necessary information is to perform your duty. Parents certainly have the right to ask for an amendment to someone's PHI. An example that for adults that I've heard before is if someone had some sort of a procedure in their past that doesn't affect their future health, but they're embarrassed by, they didn't want, future doctors to see, whatever, they can call and ask that it be taken out of their chart. If they call and ask that, you need to ask for that in writing, and the reason why they want the amendment made. It could be something as simple as you misspelled the baby's name, or something like that. That would be an amendment. You need to say, please send this in writing, an explanation for why you want this done and what you want done. And if you get that written request for an amendment, then Sarah has 60 days then to make that change within our data set, the person's PHI data set. All right, and then we briefly touched on this earlier as well, but if a person representative calls and wants to know all the disclosures of that individual's PHI or EPHI, we will provide an accounting of that. There's an appendix to your policies that sort of shows the chart that Sarah will use for that, or one of you lucky folks, if you ever take that responsibility from Sarah, if she ever puts that responsibility on you, maybe would be a better way to say it. And again, 60 days to respond to that request. And we won't charge anyone for one accounting of disclosures every 12 months. If you have a person, I can't imagine that this would happen, but if you have a person asking for an accounting of disclosures more than every 12 months, you can request a cost-based fee for those beyond the one per year. And we have now gotten through the gist of all of your HIPAA policies. Congratulations to you for listening to me for this long. Are there questions or issues that have come up in any of your brains during this presentation?
Is it considered a breach if you look up your own lab work at a hospital?
If you look up your own, well, you would be the individual in that case. So no, it wouldn't be. I mean, if you look up someone else's lab work accidentally while searching for yours, then that's actually probably still not a breach as long as you just move right past it.